Welcome back, my fellow detoxers. Today we are diving headfirst into a crazy clash between the old school and our immediate political future. It ain't every day a law written before the Civil War becomes the absolute focal point for modern political strategy, but that is exactly what is happening right now. We are performing a forensic audit on how an old federal statute designed for a nation of farmers on horseback is about to cause a literal earthquake in the upcoming midterms on Tuesday, November 3rd, 2026. Grab your focus and lock in, because we are unpacking the mechanics, the history, and the looming Supreme Court showdown that is about to redefine how America votes. First, we look at the 1845 election mandate. Second, why Tuesday in November? Third, the modern mail-in clash. Fourth, Watson v. RNC. And finally, the 2026 midterm impact. We are tracing a direct line from 19th century agrarian logistics to a very modern, high-stakes Supreme Court execution of the establishment's favorite tricks. Now let's break down that word agrarian right quick. It's just a fancy 9-letter word politicians love to throw around to sound important while they pick your pocket. It just means anything dealing with farming, planting crops, and living off the dirt. It's the sauce they use to hide the simplicity of the law. To really get a grip on today's battle, we gotta rewind the tape to the early days of American elections. 34. That represents the number of days in the wild, chaotic windows the politicians originally had to conduct their voting back in the early 1800s. States basically voted whenever they pleased within this massive time frame. Oh yeah, real organized, right? I'm telling you, it was a rhythmic heist. Early results from one state would hit the streets, sway public opinion, and unfairly tank or boost voter turnout in the very next state. The whole system was scattered, and last-minute voters were getting played by the rolling tide of early information. Sound familiar? Congress realized they had to step in and draw a hard line in the sand. On January 23, 1845, they passed the Presidential Election Day Act found in Section 2 of the United States Code. This law was designed with one distinct purpose: to streamline the entire process and put an absolute end to the 34-day free-for-all. Let's look at that word streamline, another 10-letter corporate word. It just means to clean up the mess, cut out the extra fat, and make the whole operation run smooth and fast. The bureaucrats wanted everyone on the exact same page at the exact same time. God forbid they make sense on anything else. This created a uniform national voting day. The 1845 federal standard mandated a single calendar date to completely close the election books. The goal was simple but profound: prevent staggered voting from influencing the outcome. Once that single day was over, well, the voting was over. This specific legal definition is the absolute foundation for understanding the massive legal battles that have the DC suits looking completely sideways right now. So y'all might be wondering, why did lawmakers choose this specific time? Picture the 1800s. People lived miles away from polling places. Traveling by horse to get to town took a full day. And no, obviously they didn't have GPS or a $3,000 suit to snorkel in. Lawmakers needed to carve out a 2-day travel window. Weekends were out of the question. Sunday was strictly reserved for church. Wednesday was the standard market day for farmers to sell their goods. That left Tuesday as the most convenient window, right between church and the market. And what about November? Well, that was purely dictated by dirt roads and farm culture. Holding an election in the spring messed with planting season. Late summer was out because of the harvest. November was the perfect sweet spot. It was the gap right after the harvest was done, but right before the freezing winter made travel impossible. Now, what's really interesting is when we shift to the present day, we see a massive clash. On one side, you have the strict 1-day mandate from 1845, a rule built for horses that demanded the books be closed. On the flip side, you have today's extended multi-day counting practices, heavily reliant on mail-in ballots and computer networks. I look at this and tell y'all right now, these two systems are fundamentally incompatible under federal law. 14. Currently, there are 14 states across the country that utilize their own local state rules allowing mail-in ballots to just roll in and be counted for days after the federal Tuesday deadline. Of course, the usual suspects like California, Illinois, and New York are mixed all up in this. I see exactly what is happening in places like New York and California, where the politicians have turned Election Day into a government-funded civic holiday. How convenient. While they tell y'all the goal is to give people time off, I argue this acts as a visual shield to push for permanent multi-day voting windows and continuous ballot streams. It creates a system where the counting extends well past the historical federal deadline. This sets the stage perfectly for Watson v. RNC, the Supreme Court showdown. The RNC is taking a hard-line stance. They are arguing that using local loopholes to count ballots arriving days after Tuesday is a direct violation of federal law. It illegally extends the election past the single uniform federal election day mandated in 1845. Hold up, real quick before we get to the kicker that will end the DNC's 2026 hopes. We are pushing for that next subscriber milestone, and I need my real detoxes to lock in. If you want the raw truth the media is trying to bury, hit that subscribe button right now and turn on all notifications. Don't let the algorithm box us in. Go ahead, I'll wait.
A few moments later.
Now let's get back into the Supreme Courtroom where the fire is hot. During oral arguments, the conservative majority showed some serious skepticism towards these modern multi-day practices. Justices Thomas Neil Gorsuch and Amy Coney Barrett aggressively grilled the lawyers defending the extended deadlines. They just kept circling back to the original intent of that 1845 law, questioning whether letting ballots roll in for days fundamentally violates the legal definition of a single federal election day. They are looking for the receipts. Tuesday, November 3rd, 2026. The clock is loudly ticking. The upcoming decision in the Watson case isn't just a history lesson. It's going to set the hard, non-negotiable rules for the entire midterm landscape. If the Supreme Court decides to strictly enforce the true original letter of that 1845 law, the election month scam is dead. Ha! Here's the kicker. Those days of endless vote counting are out the window once it gets to the high court. It's over for the Democrat Party to even think of winning any federal election for the foreseeable future. If y'all look at the map, it is easy to see the whole country is turning red. Those little blue portions, I like to call them ancient blue lakes, are drying up before the ink of that Democrat marker can even hit the paper. I am predicting right now, a strict ruling means any mail-in ballot not physically inside the election office by the time the polls close in 2026 goes straight to the garbage can, no matter when it was postmarked. Boom, gone, just like that. It is a stark reminder of the stakes. Should an 1845 law crafted for farmers on horseback hold the power to dictate our modern mechanics? The Constitution says yes, the law is the law, even if it doesn't fit your rhythmic heist. The Dems are panicking, and it's a beautiful, beautiful sight.